Welcome back. Now, amid national outrage over the suicide of Bengaluru Techie Atul Subhash, his wife Nikita Singhania has not made any statement so far. This, despite being more than 48 hours since the incident. Nikita Singhania's family has allegedly fled from Jaunpur. Police teams have been dispatched to look for them. Remember, Nikita's family has rejected the allegations which were leveled by Atul against him in his dying declaration and has called them unfounded. For context, Atul Subhash, the techie you see on your screens, had tragically died by suicide over the weekend, leaving behind a 24-page note and an 80-minute dying declaration in which, in meticulous detail, he had accused his estranged wife Nikita Singhania and her family of harassment and extortion.
We are currently in Jaunpur, and this is the residence of the in-laws of Atul Subhash, who committed suicide in Bangalore, claiming that he was being tortured by his wife, her family member, and in fact he also raised the questions on the judiciary system. As you can see in the visuals, the in-laws, the Singhania family, they have locked their home, and what we are learning is that they locked their home and they went away from their home last night on two-wheelers, all the family members, so they have currently left this place. Bangalore police is expected to reach Jaunpur to question the family. In fact, Bangalore police has also registered an FIR against the Singhania family, and they are expected to reach any time to Jaunpur to question the family. But before the arrival of Bangalore police, the family in Jaunpur, they have locked their house, they have left from here. Currently, they are where are their whereabouts is still to be ascertained. The local police has to say that they have not received any kind of complaint from anyone, so they are not finding the family. They don't know where the family is. When the Bangalore police will arrive, they will contact the local police, and then only the local police, the Jaunpur police, will look into this matter. But as of now, there is a lock at the gate of the Singhania family, and Singhania family is not at their place in Jaunpur.
Meanwhile, a Supreme Court advocate has written to the Chief Justice of India seeking the initiation of disciplinary inquiry, suspension, removal and prosecution of Judge Rita Kaushik for alleged corruption in the case between Atul Subhash and Nikita Singhania. Significantly, Atul had mentioned the Jaunpur judge's demand for a 5 lakh rupee bribe is one of the reasons he took the extreme step.
I have submitted a letter petition to the Honorable Chief Justice of India and also another letter petition to Honorable Chief Justice of Allahabad High Court seeking action against the concerned family court judge of Jaunpur, Uttar Pradesh. I have expressed in that particular letter petition that if no action is taken against the culprit officials, corrupt officials, then that will embolden others to indulge into such malpractices. Whereas, if strict and harsh action is taken against such people, such culprit officials, then that will act as a deterrent and others will be deterred to act into such kind of malpractices. That there is a gross misuse of matrimonial laws in India.
Meanwhile, amidst all of this, the Supreme Court has introduced an 8-point framework for calculating alimony in divorce cases. The decision coincides with the growing concerns over the misuse of dowry laws, especially alimony regulations, spotlighted by the tragic suicide of Atul Subhash. Remember, as we told you, his allegations of harassment and extortion by his wife and in-laws have reignited discussions over the abuse of legal provision. Now, some of the factors outlined are the socio-economic status of the husband and wife, educational qualifications, and employment statuses of both spouses, income sources and property owned by each party, and so on. To discuss this, let me go across to my guests who are joining me for this important discussion this afternoon. We have been joined by Shawnee Kapoor, who is a noted men's rights activist, someone who has been at the receiving end of the misuse of these laws. And I'm also being joined by Aditya Pratap, who is a noted advocate. Aditya Pratap, let me begin with you first. The 8 points that the Honorable Supreme Court have put out as the guidelines for deciding the alimony in a case is the socio-economic status of both husband and wife, basic needs of wife and children if they're involved, qualification and employment of both parties, means of income, wife's standard of living while living with the in-laws, if she had left her job to live with the in-laws, and the reasonable amount for a legal battle for a wife who is not working, and the future financial status of the husband and his other responsibilities and earnings. In your experience of working in the court so far, How many times have these 8 factors been factored in wherever every time a court comes up with any sort of an alimony order, especially when I'm talking about the lower courts or the family courts?
Well, the law which governs the grant and awarding of maintenance, the Supreme Court in the case of Rajneesh versus Neha has laid down concrete guidelines under which both the parties have to first furnish all and full details of the entire financials. It's a very long judgment. It's a very comprehensive list, be it your shareholdings, bank account statements, employment offer letters, salary structure, TDS, everything is to be placed on record for the court to arrive at a fair observation. So the first step is in any maintenance case, not just select few, in all maintenance cases, be it under Domestic Violence Act or be it under the Hindu Marriage Act or any other law, first and foremost, the court asks, or maybe under 125 CRPC also, the court first asks both the parties to first provide the entire financials to the court. Once bank statements, everything you can think of. Once both parties have provided last 3 years financials to the court proceeds to ascertain the standard of living of each party. The court ascertains what are the necessary expenses, what are the discretionary expenses, where is money being shuttled around here and there. And finally, the court says that the wife, and remember, it's like if it's under DV Act, it is the wife. If it is under the Hindu Marriage Act, then it is any spouse is entitled to the equal standard of living, compatible standards vis-a-vis the other spouse. For example, if the more affluent spouse is living in a posh colony, then the other spouse also the court will award equivalent sum so as to take a house on rent in a posh colony. So equal standards is very important, which applies here. And likewise, even if I apply this case law ratio to the Bangalore case, had the court proceeded in accordance with the law, 3 years financials of both the parties have to come. Whichever party claiming maintenance, he has to justify his claim. The party for the other spouse who's opposing maintenance can point out. He can show how the other spouse is capable of supporting himself or herself. So I would like to say that through time-honored precedents by Honorable Supreme Court and plus numerous other high courts, the law on maintenance is very well laid down. And to the extent I would say that if the procedure prescribed in the judgments is followed, the issues like a lot of case law has been decided and the decision-making process even for judges becomes easier. I have myself appeared in several maintenance cases, and when we argue such cases, we look at the entire bank statements of all the parties. Then we point out that these are in this spouse, he's wasting all his money here and there. He's giving private loans. He's not giving a rupee to his wife. So no, whatever the point is, even if any spouse puts an unreasonable demand before the judge, even if an unreasonable demand is put before the judge, it is the duty of the court to come to look up the Supreme Court rulings and pass a reasoned order which is in compliance with the law.
Okay, but the point is, Aditya Pratap, and let me also get in Shoni Kapoor and also Barkat Trayan, who's joining us at this point. This is assuming, the problem is a lot of our understanding, a lot of people have never gone through this process. A lot of our understanding of what happens in a divorce is what we see in films. We just sign a couple of documents and then divorce is granted at this point. Shoni Kapoor, this 8-point guidelines, if they're ever put in place, are for times when it comes into contested divorce, when there's actually an official alimony case being fought. In most cases, both parties go in for a mutual divorce, because obviously the first thing told to both parties is if you go in for a contested divorce, case will go on for 15-20 years, your entire future will be destroyed. So both parties go in for a mutual divorce, in which both parties are supposed to, at the end of the day, put a common petition in front of the judge with common grounds of separation. To reach those grounds, there is a mediation which happens, there are family court judges which get involved, there is pressure tactics applied from one party's lawyer to the other, and that is where these demands of crores in the form of settlement come out. And that's exactly what we saw in Atul Subhash's case. That demand for a 3 crore was happening in the family court of Jaunpur.
Yeah, so thank you very much for having me here. I have read these guidelines over and over again, and they are not put into practice by any courts in India. That is very unfortunate. They say that we have to look at living standards, but the woman comes with a demand that I was harassed at my matrimonial house, I was not given food, I was not given a car, nothing, no servants. And when she claims maintenance, she says that They are living lavishly. They have 10 servants. Where were those 10 servants when you were writing a domestic violence complaint? Why were those servants not put to use then? In fact, for property claims and alimony, I think to promote fairness of matrimonial dispute, law governing alimony and property division should consider the duration and nature of marriage as well. In this particular case, they stayed together only for 1.5 months, and there was a demand of 3 crore rupees. How can it be? Only if there is a sustained marital period, only if the woman is not earning, only if the woman has genuine requirements, like a child is there or the woman has left the job to take care of the family, there should be significant claim. Otherwise, it should be at the level of sustenance also. That will prevent exploitation while ensuring that legitimate claims are honored. A lot of places, this guy was earning 84,000 rupees as per the records, as per whatever I have heard. He was earning 84,000 rupees. The lady was granted a maintenance of 40,000 rupees. Out of 84, he was paying 40,000 to a woman who was already earning 60,000 rupees. And the demand for alimony was 3.3 crore rupees. I don't know how many years this man would have slogged or earned to give that kind of amount to that woman. Was it ever possible? And the conduct of the judicial officer, which he has noted down, the judicial officer laughed and said that she thinks that you have that kind of money. That is why she is demanding it. And the court official comes to him, demands a bribe of 5 lakh rupees for bringing this price down. Mind it. Not saying that no alimony will be granted. She was already getting 40,000 rupees. The bribe was demanded to get the money down. The demand should to reduce the demand. I don't know whether these guidelines and the guidelines gives a lot of discretion to the judges. It is not you read the guidelines again. The future earnings, the future potential. How does one ascertain the future potential in this era when jobs day in day out?
Shani Kapoorji, you can talk from anecdotal evidence. These are guidelines for when there's a actual alimony course being fought, when there are negotiations happening between parties. If there is a domestic violence case or a 498A which has already been filed on the husband's family at this point, the demand is put in front of a police station that if you want these cases to be reduced, then agree to a 3 crore alimony or something in crores at this point, and then we will go to the judge together saying that both parties are agree with it. That is how arm twisting happens. And clearly the Supreme Court is not aware of what happens in the lower courts or what happens in the lower arms of the judiciary when it comes up with lofty guidelines, whether it be talking about alimony guidelines or whether it be talking about 498A being misused.
See, my straightforward answer would be 498A is misused, domestic violence is misused, all the other women-centric laws are misused, and the courts are very aware about it. Now I'll tell you why these women are coming with 3 crores, 4 crores. I know of a woman who demanded 10 crores from her husband who was not even earning well. She said, "Ghar becho, दुकान बेचो, सब कुछ बेचो, पर मुझे 10 crore रुपए चाहिए, otherwise all people from your house, your extended family as well will be behind bars." This is every day we hear all these cases because the husband sides, mothers and sisters come crying with all this that my daughter-in-law is beating me up. She's not giving me food. She is not letting me eat medicines. She is saying, "Mere ko property, mere naam likh do." I'm just quoting this, what they have said in Hindi, because to get people understand that what is happening in houses. This is happening in the houses. No police or no other person can monitor what is happening inside the house. But yes, it is happening because these laws are highly misused. And about alimony, these lawyers only teach them. Each and every lawyer, I can name those lawyers, those who teach women that go and tell your husband, that I am filing a case on you, not only on you, the brother-in-law, the sister's husband, my father-in-law. I'll file rape cases if you don't surrender to my demands. And my demands are, I want this house as well. I want the whole house. My boyfriend is going to live here. You will not live here. Neither the family members will live here. And you have to give me
Okay, so you're saying that it's important
amount of
that a
money
very important
which
cog
I
in
will
this
use.
entire extortion machine are lawyers who encourage clients, especially women, to come up with a package of cases. I have an advocate with me at this point, Aditya Pratap. Is this something which the Supreme Court needs to take cognizance of? In your understanding here, is that a problem here? Because there are lawyers, there are advocates, and we have been hearing this from even people within the fraternity for the past 2 days, that there is often a package of cases which are offered to any woman who comes up, and to be in fact, even to a man as well. When they come up to a lawyer asking for legal advice, saying that मेरे घर में problems हो रहे, marital में मुझे शायद divorce करना पड़ेगा, मुझे separation चाहिए. And the first thing a lawyer tells, unless a lawyer is known to this person, is that मैम आप ये केस डाल दीजिए, आप जल्दी रेजोल्यूशन हो जाएगा, आपको मुंह मांगी एलिमनी भी मिल जाएगी.
See, first and foremost, I disagree with this notion. This is a very childish and immature-ish comment. To begin with, yes, I as an advocate, when I have argued cases of 498A, I myself do 3-4 cases. If a woman approaches me, I can do a case under Domestic Violence Act. I can file a criminal complaint FIR under 498A. Plus, I can also file a suit for divorce or whatever. 3 to 4 cases. These are concurrent remedies which the law permits. If the law gives parallel concurrent remedies on independent causes of action to any party, that party can avail of the same. Now, coming to the second part, where they say, I'll file rape case, this, that. Let me tell you, any responsible advocate worth his salt advises against filing a rape case unless until there is concrete proof. We tell our clients that, okay, you think filing a rape case is so easy. If one matter I advised, I told not to file this matter. I said, tomorrow, where is the medical? Where is the proof? If you have intercourse, and then first of all,
But then
there's no
Aditya,
concept of
why is a
matrimonial rape in
divorce?
India.
Why is
There cannot
filing
be
a
rape
fake
between a
498A case so easy? You just mentioned in your argument at this point that these are remedies available by the law. Just because there is a remedy available by the law doesn't mean they should be misused. Why are these concurrent cases always filed? Sometimes a divorce can just happen because husband and wife don't get along together. Doesn't necessarily mean that every case of a marriage breaking down is because of domestic violence.
See, the point is simple. When a divorce case, any party can file, that is husband or wife, anyone can file the divorce case. For domestic violence and for criminal complaint under 498A, there has to be prima facie proof of cruelty. Cruelty can be in so many forms. Economic cruelty, verbal cruelty, emotional cruelty, psychological cruelty, physical cruelty.
And are you saying that lawyers advise due discretion in filing a case of cruelty just like they advise due discretion in the case of filing a false rape case?
See, remember, there can be no rape between husband and wife apart from unnatural sex. So obviously, any allegation you levy, remember, every person is advised. If you levy any allegation, you should have some proof for it. That proof can be in the form of oral evidence. It can be in the form of documentary evidence, or maybe in the form of circumstantial evidence. But always, proof is essential, because if your allegations fail and the accused person is acquitted, then he can file a counter complaint against you, which was under the erstwhile IPC 211, and now we have also under the...
Shoni Kapoor, very quickly, does that happen when false cases are proved? Does it work out for a man to then file a case against a woman for filing a false case? Is there ever any remedy?
Yes, we can file.
1 second, Barkaji, I'll come to Shoni Kapoor. Shoni Kapoor, please go ahead.
I want to make a
1 second, Shoni Kapoor has the floor. Please go ahead, Shoni Kapoor.
211 cannot be filed by a private person. It can only the presiding officer can order a FIR under 211. The private person cannot file a 211. Again, let me tell you something, that till 2014, there were rarely 377 mentioned in any FIR of 498A. From 2014 till 2021, 377 became the major allegation.
And that's because 498A got diluted. The Supreme Court mandated that automatic arrest cannot happen with 498A. So 377 became the new law to misuse.
Yes. And after 2021, when Delhi High Court said that there shouldn't be any arrest in 377 also, now sexual harassment 354 against brother-in-law 376, attempt to rape, all these cases are now filed along with 498 and 406. And I think in the matrimonial disputes, evidence-based allegations should be given priority. The assumption that allegations made by one party, that is women, are automatically credible. It should be revisited. The burden of proof should be with the accuser, and it should not shift. Here, when we go to the courts, when we go to the police station, they say that no woman files a false case. But tell me, are there so many people who are raping their daughter-in-laws? Are there so many people who are having unnatural sex and they suddenly
Exactly.
started having
So
unnatural
there
sex
is a
as
very
per
clear
the matrimonial
distinction between, there is a very
element?
clear difference between what the Supreme Court says in terms of observations or what a top court says and what really happens in a lower court, in a family court, in a police station, and so on. So, and that
Lower
that
court,
divide from
lower
reality
court,
is what is
let
leading
me
to
tell
the
you,
case of
let me
people
tell
like
you,
Atul
lower
Subhash. I
courts
also
and police
wanted to point it
stations
out. We didn't
are
touch upon this
all
argument, but there are also genuine cases of women needing alimony. And my concern at this point is that we reach black and white status and where we say that the laws need to be changed completely or diluted. They need to be applied on a more intelligent basis. Thank you so much, Rani Kapoor, Barkat Rayan, and Aditya Pratap. This will be an issue which will rage on through the day, and we will meet you again this evening. But for now, thanks for watching Mirror Now.